Can you say and spell first and last?
Kevin Mannix, Kevinmannix.
And then, Kevin, we're talking about this ballot initiative. So can you kind of just start off on like what this is and
Sure.
why it's important?
The Oregon Crime Fighting Act is a citizen initiative where we will be gathering signatures to put this on the ballot. Sadly, it can't get on the ballot until November 2026, but we are starting this now, so we'll have plenty of time to gather enough signatures by July 2026. And the whole point of this is to eliminate catch and release, the ill-advised public policy established by the legislature during what I call the COVID session before I had returned to office. And that basically severely limits the bail authority of judges and requires that the vast majority of people who are arrested be released on their own recognizance right after they are booked, without any evaluation as to whether or not they should be held and arraigned in front of a circuit judge to consider their background and the crime charged and whether they should be held pending trial.
So explain what the status quo is right now and why we have it.
The status quo right now, and it's amazing, there's over 150 felonies and most Class A misdemeanors where the presumption is that when you are arrested, you will be released on your own recognizance, meaning you say, hey, I'm going to show up for trial. And no bail is posted. Nothing is done to hold you until trial, despite what you may have been accused of, despite what you may have done. Now, if you have a terrible record, there's some exceptions. But generally speaking, if you're arrested for burglary, auto theft, identity theft, theft in the first degree, those kinds of crimes, or failure to register as a sex offender, you are immediately released after you are booked. It is a ludicrous law, and we are now fighting to eliminate it. And I did give the legislature proposed legislation in 2023, 2024, and 2025 as a state representative to reform this law. We did not get any hearings. There's been no progress. So now I'm going to the voters along with Mike Sewell and Frank Salerno, and we're saying to the voters, let's get rid of this stupid catch and release law so that law enforcement can do our job and we can be kept safe.
How long has the law been in place?
It's been in place, in effect, since the middle of 2023. What the legislature did was they directed the Chief Justice to write up the rules for this. So in sleight of hand, the legislators themselves were not taking responsibility for what they told the Chief Justice she had to do, which was issue rules establishing the catch and release system. And she did her job. I'm not blaming her for it, but it was a stupid assignment to give to her.
To essentially say officers, booking agents make the call before the judge does so that we don't clog up the jail. What was the purpose of this?
Well, the purpose was to say, gee, most people ought to be out free pending trial. And so we're going to make a presumption that you will be out free pending trial. And what that means is you're arrested, you're booked, you're fingerprinted, you're photographed, and you're let go. By the officer who has to do this in the jail is called the release officer. And the officer's job is to release you unless there's some overwhelming reason why you shouldn't be released. And if you're charged with a violent crime, that's an exception. But otherwise, I mentioned some of the crimes. It's ludicrous that these folks are not being arraigned, brought in front of a circuit judge, which is the system we had since 1859. When you're charged with a crime of this nature, a circuit judge looks at your record, looks at the charge against you, looks at the evidence, considers whether or not you're going to show up for trial, can decide to set bail, or can decide that you should be kept in jail pending trial. That system has basically been set aside in favor of having a release officer, not an elected judge, make a decision. And the decision is driven by the rules. And the rules are, the presumption is you're being released. So law enforcement know that if they bring you in for burglary or auto theft or identity theft, the odds are you're going to be released right after you are booked. And that is ludicrous.
My understanding, too, is that some of this was because of the large dockets that we have right now with judges, and then also with the public defender crisis. If the judge is making that call, a public defender would need to be present at the time, right? And so I wonder.
Well, actually, at arraignment, the judge can decide to appoint a public defender. You don't have to have a public defender before you are arraigned, and arraignment has to occur generally within 24 to 48 hours, certainly within 72 hours. So there was a system in place. And the lack of public defenders is a separate issue. That is an issue that needs to be addressed, and it can be addressed. But you don't deal with the lack of public offenders by not prosecuting crimes, which basically is what we're heading towards with a large number of folks who don't show up for arraignment, even when it's set later on.
Yeah. With the judicial branch telling the officers this is when you would release someone, this is when you wouldn't, isn't that essentially saying here's what a judge would do anyway?
Well, we want judges to do what judges would do. That's why we have judges. They have to have very good legal backgrounds. They have to know the law. A release officer is limited in making a decision based on a set of rules put in front of the officer, and that is not a judicious decision. That is a system that is driven by a desire to let people go, and without requiring that they show that they're actually going to show up for trial, and without considering the record that they have. And that's why I use the word ludicrous. I'm amazed that the legislature during the COVID session, when most of the proceedings were done via Zoom and then they would finally show up on the House floor to vote things in, they were convinced this was all about bail reform. No, it's not. It wasn't about bail reform. It's about releasing people in a catch and release system where no judicious decision is made as to whether or not they should remain in jail until trial.
Do you think that with a judge they would actually not make some of these decisions to release, or is it more because they're elected?
The judges would understand that in each case, they are driven by this initiative. It says, consider the charges, consider the evidence against the person, consider the person's record, consider the likelihood that the person will show up for trial, consider the safety of the public, and consider the safety of the victim. Thinking about all of that, the judge is supposed to make a decision. There is not a process right now where the release officer is required to do that. There's charts and graphs, and the release officer says, well, you're charged with burglary, but you don't have a violent crime charge here, so we're releasing you. It is not a careful judicial process, and we need to change that. By the way, the way people can change it is we've set up the Oregon Crime Fighting PAC. They can write us to send a contribution or to sign up. Oregon Crime Fighting PAC, 2007 State Street, Salem, Oregon, 97301.
Where are you at with the signature gathering process?
We started just less than 2 weeks ago, and we have close to 1,000 signatures already. We need to have over 1,000 verified signatures to start what's called the ballot title process. And we want to get that started within the next 2 to 3 weeks. That will then take a few months because it's subject to litigation. But we're very close to getting the signatures we need to start up, although folks can contact me at kevin@mannixlawfirm.com if they want to get a petition sent to them for them to sign and send in for us to get this thing rolling.
Anything else you would add that we haven't covered here?
Well, I think it's important for everyone to realize that the citizen initiative process is available when our elected officials have failed to do their duty. And in this case, I think the legislature failed to do its duty in allowing this kind of law to pass and then having the Supreme Court have to put it into effect. And we're now seeing the bad results of this, and we have an opportunity to reverse it very effectively.